of Nelson Mandela Foundation Trust. This is Afri Fulham.
Good morning, my lord. I confirm my appearance on behalf of the Mandela Foundation. Candy initial R.
Thank you.
My lord, I'm for the second applicant.
Thank you.
I appear on behalf of the second and the third respondent, my lord.
Thank you.
My lord, I appear on behalf of the first respondent and the second applicant.
Thank you. We, the people of South Africa, proclaimed the preamble to the Constitution of the Republic of South Africa of 1993, the interim constitution. This was the first time that the people of South Africa expressed their oneness as a nation. It is a oneness that we reiterated in the Constitution of the Republic of South Africa of 1996 that came into operation on the 8th of May 1996, replacing the 1993 interim constitution following the historic, emotional, and near magical first democratic elections of 27 April 1994. The Constitution and the first democratic elections brought all of us together across racial, ethnic, language, cultural, gender, and sexual orientations. This and the significance of that day has etched itself in the collective memory of the nation as the Freedom Day that we celebrate each year. Prior thereto, South Africans were divided amongst each other on mainly racial basis from cradle to grave, and were denied by the apartheid rule an opportunity of common nationhood and oneness. The so-called unity achieved under the Union of South Africa 1990-10, or through the Republic of South Africa Constitution of 1961, was one based on racism, as it united the white, English, and African-speaking parts of the population, whilst excluding all the blacks, including the indigenous African population. The 1994 election and the subsequent 1996 constitution remain unparalleled in unifying all South Africans and thus etching for the first time the emotional and constitutional unity that we can all be proud of. The new constitution defines us as one nation, united in our diversity. This case drags from our recent ugly past into our current non-racial democratic dispensation. The old national flag of South Africa, introduced from 51 May 1928 and used throughout apartheid until it was abolished on 27 April 1994, in bracket, the old flag, and raises the question whether this gratuitous display constitute hate speech, unfair discrimination, or harassment against those that it never represented. The official status of the old flag as a symbol of the country came to the end in 1994 April, when South Africa was liberated. The first applicant, the Nelson Mandela Foundation Trust, hereafter referred to as the Mandela Foundation, seeks an order declaring that any display of the old flag that does not serve any genuine journalistic, academic, or artistic purpose in private interest, i.e., gratuitous display, constitute as against black people 1. Hate speech under Section 10 of the Promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000, which we shall call for short Equality Act. And 2. Unfair discrimination under Section 7 of the Equality Act. 3. Harassment under Section 11 of the Equality Act. The first respondent, AfriForum, opposes this relief in its entirety and contends, amongst others, that, quote, displaying the old flag is constitutionally protected expression, close quote, under Section 16(1) of the Constitution. It contends also that Section 10(1) of the Equality Act expressly regulates words and, as such, does not apply to other forms of expression like symbols, and that it accordingly does not regulate displays of the old flag. The second applicant, the South African Human Rights Commission, supports the relief sought by the Mandela Foundation, and in the alternative seeks an order declaring that Section 10 of the Equality Act is unconstitutional and invalid to the extent that it restricts the type of expressions which may constitute hate speech to words only. Its main contention, which is similar to that of the Mandela Foundation, is that correctly interpreted, the section encompasses all forms of expression, including flags. The second and third respondents, respectively, the Minister of Justice and the Department of Justice and Correctional Services, which I shall call for short the Department, supports the relief sought by the South African Human Rights Commission, and in relation to the alternative relief, also sets out how it intends to correct the defect. The first amicus curiae, the Johannesburg Pride, argues that the gratuitous display of the old flag amounts to hate speech, discrimination, and harassment, not only against black people, but also against members of the LGBTI plus community. The second amicus curiae, Federasie van Afrikaanse Kultuurvereniging, the FAK, submits that displays of the 1928 flag should not be banned. It in effect supports AfriForum. It should be noted that the dispute and the proceedings were initially between the Mandela Foundation and AfriForum. All other parties joined later, having been granted leave to intervene or having been admitted as friends of the court. Once the South African Human Rights Commission raised the constitutionality of Section 10 of the Equality Court, albeit in the alternative, the case required the court to sit both as the Equality Court and as the High Court. The parties agreed that this matter be determined by way of application proceedings without any oral evidence being led. Evidence was therefore presented by way of affidavits. The parties which came into the matter after the agreement confirmed that they associate themselves with the agreement for the matter to proceed as agreed. In a full judgment which I hand down today, and which must be read in its entirety and not restricted to what I say here today, in order to appreciate the conclusions I reach, I posit that at the outset, it is important to remind ourselves of the constitutional values of democratic South Africa and how under the Constitution all South Africans stand united in their diversity. In this regard, it bears recalling parts of the preamble and section 1 to the Constitution. The preamble. We, the people of South Africa, recognize the injustices of our past, honor those who suffered for justice and freedom in our land, respect those who worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representative, adopt this Constitution as the supreme law of the Republic, so as to heal the divisions of the past and establish a society based on the democratic values, social justice, and fundamental human rights. Lay the foundations for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by the law. Improve the quality of life of all citizens and the potential of each person, and build a united democratic South Africa able to stand its rightful place as a sovereign state in the family of nations. End quote. Section 1, A to B, reaffirms, and I quote, South Africa is one sovereign democratic state founded on the following values. A, human dignity, the achievement of equality and the advancement of human rights and freedoms. B, non-racialism and non-sexism. C, supremacy of the Constitution and the rule of law. Close quotes. The common cause facts have their genesis in nationwide public demonstration that took place in South Africa on 30 October 2017 against farm murders and violent attacks against farmers. The demonstrations were dubbed as Black Monday. During the protest march and demonstrations, at which AfriForum played a central role, certain protesters displayed the old flag. The display of the old flag gave rise to a dispute between the Mandela Foundation and AfriForum concerning the contemporary displays of the previous official flag of South Africa. The demonstrations and the debate that ensued received nationwide coverage forward by members of the public, including via social media. They gave rise to the complaint being lodged with the Equality Court and the subsequent conditional counter-application for constitutional invalidity in the High Court and the joint and simultaneous hearing. The founding affidavit of Mr. Sello Hatang, the Chief Executive Officer of the Mandela Foundation, describes in paragraphs 11 to 15 the events and how they affected him. The part that deals with how the events affected him read, quote, how it affected me. On that day, I was giving a guided tour of Robben Island as part of a visit jointly hosted by the Foundation and the Ahmed Kathrada Foundation. While reckoning with the pain that Nelson Mandela and his fellow political prisoners endured on the island, reports of the displays of the old flag by the Black Monday demonstrators were brought to my attention. Two painful personal memories immediately invaded my mind. A. Firstly, I remembered that when I was about 10 years old, I was walking with my brother in Stelfontein, and two white boys said to us, "Wat soek julle hier, kaffers?" My brother signaled that we should ignore them and keep walking, which we did. But he later explained to me that the word denoted hatred for black people and was used to humiliate black people. It is my first vivid memory of being told that I was not only other, but less than human because of the color of my skin. B. Second, I remembered occasions later in my childhood during school holidays when I heard white children singing "Daar kom Abobejan" as my grandmother walked past them on her way to work. While school holidays should be a joyful time in any family community, it pained me to know that my grandmother hated school holidays because she would have to navigate her way to work as a domestic worker through groups of idle white children subjecting her to this kind of abuse, and she was powerless to do anything about her trauma and anguish. The reason these memories came involuntarily to mind upon hearing reports of the old flag being displayed is that the old flag represents nothing other than the inhumane system of racial segregation and subjugation that governed South Africa before 27 April 1994, which manifested in various forms since the 1600s and became formally known as the Apartheid from 1948. It was that system, that flag which licensed, it was that system under that flag which licensed those white children who still haunt my memories to dehumanize me, my brother, and my grandmother in the way that they did. To hear the old flag had been displayed gratuitously in 2017, more than a generation after apartheid had been abolished, reminded me that some South Africans still see me and other black people as other and would deny us the opportunity just to be human. They have no concern or compassion for the suffering that the majority of South Africans endured during apartheid and continue to bear as a result of apartheid. End quote. It is common cause in this case that the description of how the events were experienced and affected Mr. Hatang reflects the reality of the feelings and experience of the black child raised under apartheid South Africa. This is how black people would have experienced the display. It is common cause also that the feelings are real. The feelings and the evidence could have been that of any other black person to whom apartheid rule and oppression represented a painful reality, no exaggeration. It was their common hope that 1994 would have put this behind forever and never to be brought back again. The never again and never again hope. The response of AfriForum is that the old flag code has a capacity to cause offense and emotional stress, close quotes. Furthermore, AfriForum, while acknowledging the truth of the experience of Mr. Hatang, simply states that South Africa has moved on and expresses a hope that when he next sees the old flag being waved, Mr. Hatang will feel differently. Quote, he could use the opportunity to reflect on how far we have moved on as a nation, close quote. Save to criticize one journalist for posting a non-Black Monday related tweet of persons wearing the old flag and banning the new flag, AfriForum does not deny that the old flag was displayed during the protest march. The case essentially turns mainly on two things, namely the old flag and hate speech. These are therefore the two main topics that this judgment will discuss in order to answer the question whether the display of the old flag constitutes hate speech today. If it does, then the final question will be whether such display is an expression that is protected by the provisions of the Constitution which guarantees freedom of expression. Unfair discrimination, harassment will also be considered, as these are alleged to be the impact of gratuitous display of the old South African flag as well. Turning first to the flag. The Constitutional Court has time and again emphasized the importance of historical context when considering human dignity, especially the history of racialized inequality in South Africa, the unique attribute of which was the denial of human dignity to black South Africans. One of the specific goals of the current Constitution is to redress the legacy of race-based inequality which was characterized by the denial of dignity to black South Africans. The value of history as an interpretive tool was emphasized again recently in 2018 in Rahube, where the Constitutional Court stated, quote, the historical context within which a particular provision operated or in response to which it was enacted has been used as an interpretive tool by this court on a number of occasions. In Brink, this court recognized that the interpretation of Section 8 of the interim Constitution, now Section 9 of the Constitution, the right to equality, involved a historical inquiry. This court held, quote within quote, as in other national constitutions, Section 8 is the product of our particular history. Perhaps more than any of the other provisions of the Bill of Rights, its interpretation must be based on the specific language of Section 9 as well as our own constitutional context. Our history is of particular relevance to the concept of equality. The policy of apartheid in law and in fact systematically discriminated against black people in all aspects of social life. The deep scars of this appalling program are still visible in our society. It is in the light of that history and the enduring legacy that it bequeathed that the equality clause needs to be interpreted. End quote. Finally, a lesson from our history is underscored by the Constitutional Court again in the matter of Garvas, is that, quote, ours is a never again constitution. Never again will we allow the right of ordinary people to freedom in all its forms to be taken away, close quote. The old flag must accordingly be interpreted against its history and meaning in order to ascertain its objective meaning and thus to assess the effect of its display on the rise to dignity and equality. It is first necessary to understand its origins and history, and I'll take a short time to deal with it. Some detail is necessary for an understanding of how it was conceived, where that flag is today, and what it represents on the one hand to a section of the white minority, and on the other to the majority comprising mostly black people. The British flag, also known as the Union Jack, was the official flag of the country prior to the adoption of the old flag, because the Union of South Africa was then considered to be part of the British Empire. The first call for a recognition of a national flag was made by the Cape Conference of the Nationalist Party in 1919. The demand was repeated in 1921 when the Free State branch of the National Party held its conference. For General Smuts, who was then leader of the South African Party and Prime Minister of South Africa, the flag issue was a sensitive one, which he did not touch, because for him, the unity between the English and the Dutch-speaking whites was paramount. In 1924, the South African Party of Smuts lost the general election to a coalition of the Labour Party and the National Party. A new government, referred to as the pact government, was formed. J.B.M. Herzog, the head of National Party, became Prime Minister. The debate about a new flag would now be resurrected. In 1925, the Minister of Interior, D.F. Malan, was responsible for the introduction of Afrikaans as the second national language, replacing Dutch. He was also instrumental in proposing a new flag through the Nationality and Flag Bill. The bill, however, was withdrawn before its second reading. Malan, however, pointed to the need for a new flag that would, quote, accept as the united choice, that would be accepted as the united choice of all sections of the nation through their recognized political leaders, close quotes. This was with reference to only white people. By 1927, the English and Afrikaans-speaking representatives in the whites-only parliament were able to reconcile their differences and agree on a new flag. The flag was adopted in June 1927 and would enter into force in 1928. Its purpose was twofold: to serve as a distinctive marker for severing the ties with the imperial power, Britain. It was also a nationalist symbol of unity between English and Afrikaans speakers. The Union, Nationality and Flag Act of 1927, to which I shall refer as the Flag Act, was passed alongside the Immorality Act of 1927, which outlawed, quote, illicit intercourse between Europeans and natives, those quotes, and the Native Administration Act of 1927, which made the Governor General, quote, the supreme chief of all natives, close quotes, and gave him vast powers to appoint and depose native chiefs, and generally to control how black people occupied and used land, moved, married, inherited, and settled disputes. It was control from cradle to grave. He controlled even where they could and could not bury their dead. These laws paved the way for the subsequent notorious Herzog Bills of 1936, the Native Representative Bill, to further limit franchise, the Native Trust Land Bill, to intensify the land ownership restrictions set by the Native Land Act of 1913, and the Urban Areas Amendment Bill to limit natives residing in urban areas only as laborers for whites. The bills in due course became law. Under these laws, urban areas were for whites and not for blacks. Black people could only lawfully enter and remain in the urban areas as laborers for white masters. Blacks were laborers and whites were masters. Literally, every white person had their own black persons as laborers. A situation not very much different from slavery. Only a bit different because a stipend was paid by the white master to the black worker. but regulated mostly by the will of the master. Viewed in this context, the Flag Act was part of a scheme of statutes that were intended to entrench, and in fact did entrench, racialized segregation and white supremacy. The old flag, or the Apartheid flag as it is sometimes called, was a vivid symbol of white supremacy and black disenfranchisement and suppression. It combined four flags: the British Union Jack and the flags of the Transvaal and Oranje Vrystaat republics founded by the Boer settlers on the background of the Oranje Blanche Blauw Dutch Prinsenvlag. It gave expression to European heritage and heraldry, excluding black people entirely from the project of, quote, binding together of all sections of the people in one common sentiment, close quote. It certainly still means one thing to some, in bracket those who did not suffer and benefited under the pre-democracy or apartheid rule, and another thing to others, in bracket the victims, and those who, though not victimized, were genuinely opposed to the apartheid rule. It is unfortunately still divisive. When a democratic dispensation was forged in 1994, what South Africa needed was a new identity which broke away from her racial past, in which unity had been identified and defined as unity between Afrikaans and English-speaking population to the exclusion of the blacks. South Africa needed a new all-embracing unity that unites all her people, broke with the past, and looked only to the future. The new constitution and the new national flag defined the new South Africanness explained in the first paragraph of this judgment, one that would never look back to her past. The current flag was accepted as the united choice of all sections of the nation without exclusion through their recognized political leaders. It is against the backdrop of this history and the current divergent interpretations of the flag that its true and objective meaning must be assessed. Each of the parties set out what meaning they each attach to the old flag. That, I suggest, is a helpful starting point for the current purpose. The Mandela Foundation testified that, quote, the old flag represents nothing other than the inhumane system of racial segregation and subjugation that governed South Africa before 27 April 1994, which manifested in various ways since 1600 and became formally known as apartheid from 1948, close quote. Pride, similarly, quote, associates the old flag with autocracy, oppression, and denial of human rights, injustice, inequality, and hate. The Human Rights Commission testified that the old flag, quote, constitutes a symbol of racist and oppressive regime that governed South Africa prior to democracy and the dehumanizing ideologies espoused during that regime, as specifically that of racial superiority of white South Africans, and inter alia, the corresponding inferiority of black South Africans, close quote, and open quote again, has been adopted and used by white supremacists around the world as a symbol of hatred, oppression, and racial superiority, close quote. The department, meanwhile, described the old flag as, amongst others, quote, a particularly invidious image used during apartheid as the national symbol of a country that created, promoted, and brutally enforced a political system that, at its core, was aimed at discrimination and oppression, close quote. AfriForum does not dispute any of these meanings, and itself testified that, open quotes, during apartheid, the old flag was held aloft as a symbol of past regimes' power. At the time, it was seen as a constant reminder of an oppressive and racist system, close quote. As to how it is currently received, AfriForum concedes further and states, quote, most South Africans recoil from the old flag and openly denounce apartheid as a crime against humanity, close quote. Only the FAK begs to differ. It states, quote, this is with respect a stereotyped view of the flag, which has a far more complex history than this, and is capable of being viewed in ways other than being a flag that celebrates or promotes apartheid or ideas premised on racial superiority and inferiority, and that could only be displayed in a manner that is intended to be hateful or offensive, close quotes. Against those divergent interpretations, the true meaning or meanings of the old flag falls to be determined in favor of one overriding dominant meaning, and in the context, it is this. And the conclusion is based on an analysis you will find in the judgment. That the gratuitous display of the old flag visually communicates a message of the belief in or support of racism, white supremacy, and the subjugation of black population. In short, the old flag is, according to the dominant meaning, representative of apartheid, which has been declared a crime against humanity. One has to deal with the non-dominant meaning as well. The FAK holds a singularly different view to that of the other parties to the application. It advances the contention that the image is capable of an alternative meaning, and that meaning is that it is, quote, a symbol of reconciliation and unity between the English and African-speaking population, close quotes. FAK does not suggest that the image is capable of being viewed with any perception of reconciliation or unity with the majority black population. Even on their version, the old flag is therefore discriminatory, and based on a minority perception, it is therefore inherently exclusionary of black majority population who are not recognized or acknowledged in the image. This alternative meaning is fundamentally flawed. It is also not advanced as the dominant interpretation of the image. As such, on an application of the applicable legal principles, the proposed interpretation does not meet the legal threshold. It falls short even of AfriForum's admission that the old flag is offensive in the context of post-1994 democratic society. The old flag did not only operate nationally as under the apartheid South Africa. It's an image which represented the country internationally. This requires consideration of the international dominant meaning of the flag as well. From an international perspective, it is recognized that apartheid was declared a crime against humanity by the United Nations in the Convention on the Suppression and Punishment of the Crime of Apartheid, open bracket, General Assembly Resolution 3067, 1976, and ultimately the 2002 Rome Statute. These actions, the 1976 and 2002, was a culmination of prior steps by that international body of condemnation against the policy of apartheid adopted annually by the international community. Apartheid was condemned by the United Nations annually from 1952 to 1990. The Rome Statute of 2002 recognizes the crime of apartheid as particularly pernicious crime against humanity in Article 7(1)(j) and describes the crime in Article 7 brackets 2H as, quote, inhumane acts of a character committed in the context of an institutionalized regime of systematic oppression and domination by one racial group over any other racial group or groups, and committed with the intention of maintaining that regime, close quotes. Against an examination of various international instruments on the topic, the dominant and international law perspective on the point is underscored by the following. 1. The near uniform adoption of two conventions. The 1976 convention was adopted with 91 votes, 4 against. Portugal, South Africa, the United Kingdom, and the United States, and 26 abstentions. As at August 2008, the convention had been ratified by 107 states. The Rome Statute was adopted by 139 states with 118 ratifications. 2. The fact that despite the end of apartheid as a political system in South Africa, it lives on as a species of the crime against humanity, both under the customary international law and the Rome Statute of International Criminal Court. 3. The Rome Statute was adopted and signed on 17 July 1998 by a majority of states attending the Rome Conference, including democratic South Africa. South Africa ratified the Rome Statute on 27 November 2000, and in accordance with the obligation of state parties, South Africa passed the implementation of Rome Statute of International Criminal Court Act of 2002 on 16 August 2002, which is now the domestic law giving effect to the Rome Statute in South Africa. That is still law. Therefore, apartheid, which is represented by the old flag, must in South Africa, as in the international arena, be acknowledged and classified as a crime against humanity. 4. As evidenced in the affidavit of the Human Rights Commission, the flag is an internationally understood symbol of white supremacy, and as stated in the minister's affidavit, is, quote, an image that was the international symbol of apartheid, close quote. For these reasons, the dominant meaning attributable to the old flag, both domestically and internationally, is that it is for the majority of South African population a symbol that immortalizes the period of a system of racial segregation, racial oppression through apartheid, a crime against humanity, and of South Africa as an international pariah state that dehumanized the black population. It is now necessary, against that history and meaning of the flag, to consider hate speech in South African law, to determine whether a gratuitous display of the flag constitutes hate speech. Let's look at hate speech. The ordinary and everyday meaning of hate speech must be found in the dictionary. The Oxford Dictionary meaning of hate speech is speech expressing hatred, intolerance of other groups, especially on the basis of race, gender, etc., close quotes. The Merriam-Webster Dictionary defines hate speech as, quote, speech expressing hatred of a particular group of people, close quotes. The Cambridge Dictionary explained it as, quote, public speech that expresses hate or encourages violence towards a person or group based on something such as race, religion, sex, or sexual orientation, close quotes. HarperCollins English Dictionary described it as, quote, speech disparaging a racial, sexual, or ethnic group or a member of such group, close quotes. In short, hate speech is, according to this definition, speech and expresses hatred towards a person or is his or her group based on race or other attributes such as religion, sex, ethnicity, sexual orientation, and the like. It may even, but does not necessarily, encourage violence towards the group or member of such group. Away from the dictionary, now to our legislation. Section 10(1) prohibits hate speech and provides, quote, subject to the proviso in Section 12 of the Equality Act, no person may publish, propagate, advocate, or communicate words based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to A, be hurtful, B, be harmful or to incite harm, C, promote or propagate hatred, close quotes. Prohibited grounds as defined by the Equality Court is fairly broad and includes race, sexual orientation, code, or any other ground where discrimination based on that other ground causes or perpetuates systemic disadvantage or undermines human dignity, close quote. The proviso in Section 12 states that, quote, bona fide engagement in artistic creativity, academic and scientific inquiry, fair and accurate reporting in the public interest or publication of any information, advertisement, or notice in accordance with Section 16 of the Constitution is precluded by this section, close quote. The section in the Equality Court Act needs to be interpreted together with its proviso in order to answer the question having regard to the explanation of the flag and its meaning, whether a gratuitous display of the old flag constitutes hate speech under Section 10(1)(a) of the Equality Act. It is proposed to approach the interpretation within a framework which is mandated by the Constitution, international law, the Equality Act itself, and with the benefit of comparative law. It is an approach which we will refer to as the legal interpretative framework. It is then proposed to have regard to the purpose and the objects of the Equality Act itself and the language of Section 10. We turn first to what the Constitution mandates us to do. The first duty for the court to interpret hate speech provision having regard to and in accordance with the approach mandated by the Constitution. Section 39(2) of the Constitution provides that, quote, when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights, close quotes. This duty upon a court to interpret legislation in a manner consistent with the Bill of Rights was set out by the Constitutional Court in the case of Investigating Directorate Serious Offences and Others versus Hyundai, which we shall refer to briefly as the Hyundai case. And the interpretation was as follows, quote, the Constitution requires that judicial officers read legislation where possible in ways which give effect to the fundamental values. Consistently with this, when the constitutionality of legislation is in issue, they, the courts, are under duty to examine the objects and purport of an act and to read the provisions of the legislation so far as possible in conformity with the Constitution. The Hyundai Test requires that the court, 1, consider the objects and purport of the legislation under scrutiny, and 2, read the provisions of the legislation as far as possible in a manner which is consistent with the Constitution to the extent that the text is reasonably capable of bearing such a meaning. And what does international law tell us in this regard? An equally important provision of the Constitution is Section 39(1)(b), which requires that international law must be used as an interpretive aid when the court interprets the rights set out in the Bill of Rights. International law is that key when interpreting rights in the Bill of Rights. The provisions of Section 10 of the Equality Act are inextricably linked to the Bill of Rights. As set out below, Section 10(1)(a) gives effect to the following sections of the Constitution. Section 9, the right to equality, Section 10, the right to dignity, and Section 16(2)(c), the exclusion of hate speech from the ambit of the right to expression. Similarly, Section 7 of the Equality Act that forbids unfair racial discrimination is linked to Section 9 and 10 of the Constitution. Section 11 of the Equality Act is also linked to both the constitutional rights and possibly other rights in the Bill of Rights. Therefore, a court interpreting these sections must have regard to international law. However, for now, we focus on Section 10(1), read together with the proviso which deals with hate speech, and shall revert later to the other impugned provisions of the Equality Act to the extent necessary. In addition to the two constitutional injunctions, more directly, Section 233 of the Constitution requires that, quote, when interpreting any legislation, every court must prefer any reasonable interpretation of legislation that is consistent with international law over any other interpretation that is inconsistent with international law, close quote. To sum up, the requirements of the Constitution as considered by our highest courts may be stated as follows. Both the Constitution and South African law in general must be interpreted in a manner which complies with international law, if such an interpretation is a reasonable one. It follows then that when Section 10(1) of the Equality Act is interpreted, its meaning should be interpreted in a manner which is consistent with international law. If the interpretation of the section that is consistent with international law is reasonable, then that interpretation is to be preferred to an interpretation which is inconsistent with international law. Comparative law. South African jurisprudence does not develop in isolation to other comparable legal systems, although our courts are not bound by their jurisprudence. This includes, but is not limited to, our human rights jurisprudence. Our courts have thus regularly referred to foreign jurisprudence to assist them in the interpretation of legislation and the development of common law. In the present instance, it is accordingly appropriate for this court to make reference to foreign law in considering the proper scope and application of the Equality Act, particularly Section 10. This is more so the case because the direct effect of the applicant's interpretation of the Equality Act has on the right to equality in Section 9, the right to dignity in Section 10, and on the limitation of the right to freedom of expression in 16(2)(c). In addition to the injunctions and guidelines provided by the Constitution as the supreme law of the land, the Equality Act itself provides an important pointer to those who have to interpret and apply its provisions. Section 3 of the Equality Act expressly echoes the above duties to interpret that act in a manner that accords with its purpose, in consonance with the Constitution, in accordance with international law, and possibly having regard to comparative foreign law. It goes further, however, by introducing context as an interpretive marker. It is a therefore, that this court must have regard to the purpose of hate speech under Section 10(1) of the Act. Section 2 of the Equality Act also sets out its objects. Section 10 of the Equality Act must thus further be interpreted as ascribed a meaning which is it can reasonably bear having regard to these objects when viewed in the light of the Constitution. Against the backdrop of the above interpretive framework, one should now drill down to the language of Section 10 to determine its meaning in relation to the issue at hand. It bears recalling and noting the language and its verbs. The heading is Prohibited Hate Speech, and it reads, subject to the proviso in Section 12, no person shall publish, propagate, advocate, or communicate words based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be harmful, hurtful, or to promote or propagate hatred. Proviso: bona fide engagement in artistic creativity, academic, scientific inquiry, fair and accurate reporting in public interest or publication of any information, advertisement or notice in accordance with Section 16 of the Constitution is not precluded. The first respondent, AfriForum, relies on a literal reading and interpretation of Section 10(1) Act and contends that because hate speech prohibition therein refers to words, it does not apply to display of the flag, which is a symbol and not words. The literal interpretation it seeks to rely on fails to have regard to the relevant principles of interpretation which I articulate fully in the judgment as the legal interpretive framework. The reference to words in Section 10(1) must be given a generous and wide meaning going beyond mere verbal representation. There are at least four textual markers which indicate this, two of which are directly located in Section 10 itself. Firstly, the heading of Section 10 contemplates, quote, prohibition of hate speech, close quotes. When regard is had to the purpose for which the Equality Act was enacted, the provisions of the Constitution, international law, and interpretive foreign law, speech must be widely interpreted to mean all forms of expression of ideas. It is not limited to verbal representation. This is dealt with further below. The essence of speech is communication. This in turn suggests that words in Section 10(1) should not be taken literally, but should be given a wider meaning in order to achieve its purpose and broad purpose of the Equality Act. It must include in this regard all hate speech, however expressed. Speech is certainly already wider than words and sits comfortably with section read as a whole and in the context of the entire Equality Act. Secondly, Section 10(1) provides that nobody may propagate, advocate hateful words. This verbs are ill-fitting if words is taken literally. How does one propagate or advocate word? But ideas can be advocated or propagated. In order for these two verbs to make sense and be given their full meaning, the prohibition must apply to ideas, irrespective of how those ideas are expressed. Not only will these two verbs make sense, but the rest of the verbs also sit comfortably and retain a sensible meaning. Thus, the effect will be that no person may publish, propagate, or communicate words, stroke ideas based on prohibited grounds with a clear intention to be harmful, hurtful, or to promote or propagate hatred. Similarly, one does not communicate words. What is being communicated is the meaning conveyed, words being a medium and not the only one. All the verbs employed in the section are consistent with a wider meaning being attributed to words. Hence, it makes sense and it is consistent with the purpose of the Equality Act, the Bill of Rights, and international law for the section to provide that no person may publish, propagate, advocate, or communicate speech, ideas, ideologies, beliefs, meanings, instructions, etc., based on one or more of the prohibited grounds with the intention to achieve the stated effects. This wider meaning gives the subsection, read as a whole, a sensible and reasonable interpretation, and which fits in with the interpretive framework set out above. Words in Section 10.1 of the Equality Act must be interpreted to mean ideas, ideologies, beliefs, instructions, etc., conveyed by words. Words thus mean what the words convey or mean, and not just a conglomeration of letters, which, though constituting a word or words, may be meaningless in a particular context. What the section targets is thus the meaning behind words and not simply words, although the subject of the grammar is stated as words. What is behind words? That is, their meaning may be represented by verbal and non-verbal expression. A wider meaning is thus clearly the most sensible, reasonable, and consistent with the principle-based interpretive framework. It is the correct meaning. Thirdly, one of the objects of the Equality Act is set out in Section 2, brackets B, 5, is to give effect to, quote, the letter and spirit of the Constitution, close quote. In particular, the exclusion from constitutional protection of, quote, advocacy of hatred based on race, ethnicity, gender, or religion, and that communicates incitement to cause harm as contemplated in Section 16.2c of the Constitution, close quote. The notion of, quote, advocacy of hatred, close quotes, set out in Section 2BV5 of the Equality Act is broad. It cannot be interpreted narrowly to mean only words. That would run completely contrary to, quote, the letter and spirit of the Constitution, close quote. This is a further reason why words in Section 10.1 cannot be taken literally Instead, Section 10 must be read as prohibiting any, quote, advocacy of hatred, close quotes, which may manifest itself in any expression of ideas. Fourth, the prohibition in Section 10 is expressly made subject to the proviso in Section 12, which reads, quote, provided that bona fide engagement in artistic creativity, academic and scientific inquiry, fair and accurate reporting in the public interest or publication of any information, advertisement or notice in accordance with Section 11 is not precluded by the section, close quote. This proviso clearly excludes the expression of ideas, not only by words, but by means including artistic means. It makes sense only if the prohibition in Section 10 is also understood to apply to all expressions of hateful ideas, whether by words or conduct. I look briefly at the expression advocacy for hatred used in the Constitution. The Bill of Rights itself shed light on a proper interpretation of Section 10. Section 16.1 of the Bill of Rights protects freedom of expression. Section 16.2, however, excludes certain categories of speech from the protection. Section 16.2c removes hate speech from the protection of Section 16.1 by excluding any, quote, advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitute incitement to cause harm. One sees immediately the expression advocacy of hatred, which is echoed and repeated in Section 2B4 of the Equality Act. That expression, where it appears in Section 2B4 of the Equality Act, must bear the same meaning as it bears in Section 16.2c of the Bill of Rights. The prohibition in Section 10 of the Equality Act is intended inter alia to prohibit the kind of speech excluded from protection by Section 16.2c of the Bill of Rights. The Bill of Rights does not confine the exclusion to hate speech expressed in words. It thus applies to advocacy of hatred by any means, whether by word or conduct. The Constitutional Court made this clear in Islamic Unity Convention versus the Independent Broadcasting Corporation and others, that I shall refer to briefly as the Islamic Unity Convention, when explaining what genuine hate speech is. It stated, quote, Section 16.2c is directed at what is commonly referred to as hate speech. What is not protected by the Constitution is expression or speech that amounts to advocacy for hatred that is based on one or other of the listed grounds, namely race, ethnicity, gender, or religion, and which amounts to incitement to cause harm. The Constitutional Court here makes it clear that unprotected hate speech is, quote, expression or speech, close quote. It is not limited to words, the narrow interpretation that is rejected in this judgment. Although this was stated in the interpretation of the Constitution, it is an interpretation with which Section 10 of the Equality Court is required by law to be aligned with. Section 10 must accordingly be interpreted to do likewise. It would be irrational to limit its prohibition to the advocacy of hatred by words, but not by other means, because the main purpose of Section 10 of the Equality Act is to prohibit all hate speech. This is evident from the broad prohibition against advocacy of hatred in Section 2B4 described in the objects of the Act. The interpretation that AfriForum advocates violates the Constitution in several respects and is therefore untenable and unsustainable in several respects, as I shall demonstrate, particularly because, in this case, AfriForum does not seek constitutional invalidity of the section. AfriForum submits that Section 10(1) of the Equality Act applies only to hate speech communicated by words. If it were so, then the state would not be adequately protecting the right to dignity and protection against unfair discrimination of people who are subjected to hateful communication expressed in a form other than words. In other words, people who experience hate speech communicated by other forms of expression than words would not have any protection or remedies under Section 10 of the Equality Act. This interpretation does not make sense and runs counter to the objects of the Act and all the principles in the interpretive framework I have articulated. The legislator could not have intended for this to be the case. Such an interpretation is untenable. It does not accord with the wording of Section 10(1) of the Equality Act as described above. This interpretation would also irrationally differentiate between hate speech by language, which is prohibited, and hate speech by other means, which would not be protected. It would run contrary to one of the objects of the Equality Act set out in Section 2B1, namely, to give effect to the letter and spirit of the Constitution, in particular, the equal enjoyment of all rights and the freedoms by every person. And it would directly fall foul of fundamental right to equality in Section 9 of the Constitution, which provides in Section 9(1) that, quote, everyone is equal before the law and has the right to equal protection and benefit of the law. Section 9(4) of the Constitution requires Parliament to enact legislation, quote, to prevent and prohibit unfair discrimination, quote. The Equality Act was enacted to fulfill this duty. If the prohibition of hate speech, which is a form of unfair discrimination, is limited to hate speech expressed in words and does not extend to hate speech expressed in other forms of expression, the prohibition of hate speech in Section 10 and the Equality Act itself would fall short of the obligation imposed on Parliament by Section 9(4) of the Constitution to prohibit all forms of unfair discrimination, and not just discrimination expressed in the form of words. In order to pass constitutional muster, the exercise of public power must be rationally related to the purpose sought to be achieved by the exercise of that power. The restriction of the prohibition of hate speech to words only would not achieve the purpose of the Equality Act, which is to prohibit all forms of hate speech and unfair discrimination. The restriction is accordingly irrational, clearly unlawful, and must be rejected. This narrow interpretation would also be contrary to the objects of the Act itself as set out in Section 2B4 it would undermine the right to dignity. Human dignity informs the interpretation of all rights, including the right to freedom of expression and the right to equality. The right to freedom of expression must be realized in a manner that does not violate the dignity of others. And as described above, the right to equality must be realized in a manner that ensures everyone is equal before the law and has the right to equal protection and benefit of the law, so as to ensure their dignity. If Section 10(1) of the Equality Act was read as prohibiting literally only words, it would directly contravene the right to dignity in Section 10 of the Constitution of victims of non-verbal hate speech. This is because it would result in such a victim being forced to endure hatred and suffer affronts to their dignity without the protection of Section 10 of the Equality Act, simply because the aggressor chose to express their hatred in non-verbal manner. The absurdity of the interpretation advocated by Apartheid Forum is demonstrated by an example put forward by counsel, where Section 8 of the Act would prohibit a white racist from describing a black colleague as baboon in front of other colleagues, but not prohibit him from circulating an image of the same colleague, the same colleague's face superimposed on the body of a baboon. The restriction of hate speech under Section 10(1), literally to words, in this context, would not only undermine the right to dignity, but would also, quote, lead to an absurdity so glaring that it could not have been contemplated by the legislature, close quote. It is unjustifiably narrow and unconstitutional. Article 20, paragraph 2 of the International Covenant on the Civil and Political Rights, ICCPR, ratified by South Africa on 10 December 1998, provides that, quote, any advocacy of national, racial, or religious hatred that constitute incitement to discrimination, hostility, or violence shall be prohibited by law, close quote. Furthermore, Article 4 of the 1965 International Covenant or Convention on the Elimination of All Forms of Racial Discrimination, ICERD, ratified by South Africa on 9 January 1999, states that, quote, state parties condemn all propaganda and all organizations which are based on ideas or theories of superiority of one race or group of persons, of one color or ethnic group, or which attempt to justify or promote racial hatred and discrimination in any form, and undertake to adopt immediate and positive measures designed to eradicate all incitement or acts of such discrimination, and to this end, with due regard to the principles embodied in the Universal Declaration of Human Rights and the rights expressly set out in Article 5 of the Convention, inter alia, shall declare an offense punishable by law all dissemination of ideas based on racial superiority or hatred, incitement or racial discrimination, as well as all acts of violence or incitement to such acts against any race or group of persons or of another color or ethnic origin, and also the provision of any assistance to racist activities including the financing thereof, close quotes. The ICCPR prohibits, quote unquote, any advocacy of racial hatred. The ICERD provides that all state parties, including South Africa, shall eradicate, quote, all incitement to or acts of such discrimination, close quotes. It furthermore requires them to declare, quote, all dissemination of ideas, close quotes, based on racial superiority, hatred, discrimination, acts of violence, and incitements to such acts, offenses punishable by law. Both instruments are brought in their ambit. They embrace the prohibition of hate speech in the widest sense to include any expression of ideas. Neither instrument draws a distinction between verbal and non-verbal advocacy or communication of racial hatred. This court is enjoined to give effect to the objects of the Equality Act. One of the objects of the Equality Act set out in Section 2H of the Equality Act is, quote, to facilitate further compliance with international law obligations, close quotes. Furthermore, in accordance with Section 233 of the Constitution, the court must prefer the applicant's reasonable interpretation, which is consistent with international law, over the respondent's interpretation that is inconsistent with international law. In other words, Section 10(1) of the Equality Act must be interpreted in a manner that prohibits any manner of expression which constitute hate speech and not just words or verbal expression. Such an interpretation complies with constitutional imperative of ensuring consistency with international law. It also accords with one of the objects of the Equality Act, namely to facilitate compliance with international law. When interpreting and applying Section 10 of the Equality Act, a court, having regard to this context, should not limit the scope of the prohibition of hate speech in Section 10(1) to literally only words, thereby allowing expressions of hatred in non-verbal forms to escape prohibition. Short reference to comparative law. The United States First Amendment prohibits the abridgment only of speech, not conduct or expression. But the U.S. courts have long recognized that speech under the First Amendment is not limited to words, but extends to communication of ideas in the form of conduct and gestures. The following words of the U.S. Supreme Court in the case of West Virginia State Board of Education versus Barnett, going back to 1943, albeit apita, are instructive. Quote, the flag salute is a form of utterance. Symbolism is a primitive but effective way of communicating ideas. The use of an emblem or a flag to symbolize some system, idea, institution, or personality is a shortcut from mind to mind. Symbols of state often convey political ideas, just as religious symbols come to convey theological ones, close quotes. These 1943 words, or the notion conveyed therein, were referred to with approval by the same court in 1974 and again in 1989 in judgments that the full judgments deals with fully. It is thus reasonable to interpret words in Section 10.1 of the Equality Act to include non-verbal expression of ideas. This would be analogous to the broad manner in which the U.S. Supreme Court has interpreted the term speech under the U.S. First Amendment. The use of a symbol is indeed a shortcut from mind to mind. They communicate just as words do. To sum up and conclude, Section 10 of the Equality Act should be interpreted in a manner that prohibits all expressions of idea, verbal and otherwise, including the displaying of a flag, that amount to hate speech. Accordingly, words in Section 10.1 must not be read literally. It must be interpreted to be wide enough to include expressions of ideas such as the waving of a flag. Such an interpretation is not unreasonable. Instead, it ascribes a meaning to Section 10.1 and words which is reasonably capable of being borne. It accords with the objects of the Equality Act. It is consistent with international law. It is not out of kilter with the comparative foreign law. It takes into account the context of the dispute. And most importantly, it gives effect to the spirit, purport, and objects of the Bill of Rights and ensures that Section 10.1 is generally consonant with the Constitution. Accordingly, the prohibition against hate speech in 10.1 applies to and regulates the waving of the old flag. This is so having regard to the correct legal interpretation of the section that requires words in that section to be given a wide interpretation to include symbols such as the flag. On a conspectus of a case as a whole, I'm satisfied that displaying the old flag gratuitously does much more than merely cause offense and emotional stress to black people. Indeed, it bears repeating that the declarator sought is based expressly on how the display affects black people. It therefore makes no difference to my finding that some isolated person somewhere who has no idea of or is indifferent to the profound suffering endured by black people under apartheid may experience it differently. It means and dehumanizes people on the basis of their race. It demeans and dehumanizes people on the basis of their race. It impairs their dignity. The old flag is displayed gratuitously with the full knowledge of its current and historical effects, and therefore with clear intent to bring its effects upon fellow men and women. Those who display the old flag choose deliberately not only to display the apartheid discriminatory, divisive and oppressive flag, they also consciously and deliberately choose not to display the new democratic, all-uniting, non-racial flag. They choose oppression over liberation symbols. What then is their objective intention? They intend to incite and awaken feelings of white supremacy against black people. They know or ought to know that other oppression-prone whites will be incited to recall and long for days when white people exercise oppressive power over black people with the sanction of an oppressive and unjust legal system. They wish to remind black people of the oppression, humiliation, indignity, dehumanization that they moved away from and do not wish to relive or return to. They are therefore correctly described as demonstrating, quote, total rejection of tolerance, reconciliation, and all values underlying the Constitution, close quotes. They deliberately choose to reject reconciliation and embrace hatred and oppression because they incite polarized feelings. Their action demonstrates a clear intention to be harmful, hurtful, and to incite and propagate hateful feelings, not only to victims of apartheid and its legacy, but also to our nascent racial democracy. There has been no suggestion to the contrary. Not a single black person has suggested feeling embraced by the display of the flag, and not a single white person has suggested that the display is a demonstration of love and tolerance towards black people. On the very contrary, the evidence of those who oppose the complaint or application confirms that the display of the flag has potential to cause harm and distress. The very negative feeling that the Mandela Foundation, the Human Rights Commission, Pride, and the department testify is caused by the display. Such evidence is an admission and not a denial. It is true that the evidence of the supposed opposition goes only as far as admitting potential to be harmful or incite harm. However, such evidence corroborates direct evidence of the Mandela Foundation, Human Rights Commission, Pride, and the department that it is in fact hurtful, harmful, promotes and propagates hatred towards black people. Accordingly, any gratuitous display of the old flag, that is, display beyond the protection of the proviso in Section 12, besides being racist and discriminatory, demonstrate a clear intention, A, to be hurtful, B, to be harmful and incites harm, and it in fact promotes and propagates hatred against black people in contravention of Section 10(1) of the Equality Act. It constitutes hate speech. Such display is furthermore divisive, retrogressive, and destructive of our nascent non-racial democracy, the constitutional values of human dignity and equality, and a building of a society united in its diversity. It is an affront to the spirit and values of Ubuntu, which has become a mark of civilized interaction in post-apartheid South Africa. The Human Rights Commission would have sought a declaration of Section 10(1)(a) of the Equality Court as unconstitutional if it were to be construed restrictively as excluding non-verbal expression. If that were the meaning, I would have agreed. However, in view of my conclusion regarding the correct interpretation of the hate speech provisions in Section 10(1), it is not necessary for me to entertain that relief. The Mandela Foundation in addition to a declaration of hate speech, also seeks an order that the gratuitous display of the old flag constitute harassment in terms of Section 11 of the Equality Act against black people. Harassment is defined in Section 1.1 of the Equality Act to include, quote, unwanted conduct which is persistent or serious and demeans, humiliates, or creates a hostile or intimidating environment related to a person's membership or presumed membership of a group identified by one more or more of the prohibited grounds, close quotes. The Mandela Foundation testified that any gratuitous display of the old flag, quote, seriously demeans, humiliates, and creates a hostile and intimidating environment for victims of apartheid and its legacy, particularly black people, close quote. Pride, the amicus, also testified that the gratuitous display of the old flag has the effect, quote, towards members of the LGBTI community who were also victims of apartheid and its legacy. AfriForum does not deny these allegations, but contends that for conduct to constitute harassment, quote, it must amount to torment that is persistent and repetitive, close quote. There is no such a requirement in the Equality Act, and this court was not referred to any other authority for the contention. Accordingly, there is no basis for denying the order sought by the applicants. Furthermore, displaying the old flag in the face of most South Africans, knowing that they recoil from it, can only constitute harassment. It goes beyond hate speech. The Mandela Foundation finally also seeks an order that gratuitous display of the old flag constitute unfair discrimination against black people as victims of apartheid. In this regard, the Mandela Foundation testified that any gratuitous display of the old flag, quote, propounds racial superiority and like freedom of press, media, etc. Section 16.2, however, excludes certain specified categories of speech from the protection of Section 16.1. The excluded expressions can therefore simply not claim protection of Section 16.1. Hate speech is an expression which is specifically excluded from protection by Section 16.2c, and Section 16.2c does so by excluding any advocacy of hatred that is based on race, ethnicity, etc. As the Constitutional Court explained in Islamic Unity Convention, quote, "What is not protected by the Constitution is expression or speech that amounts to advocacy of hatred that is based on one or more of the listed grounds, namely race, ethnicity, gender, religion, and which amounts to incitement to cause harm," close quotes. Because this judgment finds that the gratuitous display of the old flag amounts to hate speech, that is, advocacy for hatred within the meaning of Section 16.2, it means such display enjoys no protection as free speech under the Constitution. The prohibition in Section 10 of the Equality Act is clearly intended inter alia to prohibit speech of the kind excluded from protection by Section 16.2c. Hate speech is excluded to the extent that it may fall, is excluded except to the extent that it may fall under Section 12 proviso. Gratuitous display of the old flag is display that does not fall under the proviso. The Mandela Foundation was careful to target only displays of the old flag which are not protected by Section 12. Their complaint and application can therefore not be backed by a claim that display they target is protected freedom of expression. The contention of Africa that seeks to rely on freedom of expression is therefore illogical and misplaced and stands to be dismissed. Accordingly, the gratuitous display of the old flag constitute prohibited hate speech, unfair discrimination, and harassment. Contrary to the protestations of AfriForum, the relief sought by the applicants in this matter is not a banning order against the old flag. The Mandela Foundation seeks only an order that will declare to all South Africans, including the potential offenders and complainants, that the display of the impugned flag must be confined to genuine artistic, academic, or journalistic expression in the public interest. It must qualify under Section 12 of the Equality Act. Any display beyond that may be brought before this court for the displayer to prove that the display was defensive or to prevail on the court to make an appropriate remedy. That amount of legal certainty is required to provide certainty in circumstances where the display of the old flag during October 17, so-called Black Monday demonstration, caused serious violations of fundamental human rights. The ensuing debate was fairly widely covered in the country and remained inconclusive in certain respects, leaving the door wide open for future repeat of the violation of fundamental human rights, with potential polarization of society along racial lines. Furthermore, there are prospects that in the light of the certainty that this judgment will hopefully provide, even parties that are currently opposing the application shall be strengthened in promoting the avoidance of hateful display of the old flag. AfriForum, which no doubt believed in the correctness of its submissions, has informed the court that it is a reluctant opponent in these proceedings, that it has no love for the old flag and what it represents, that it is aware that most South Africans recoil from the old flag. It also says that it, as an organization, is committed to taking active steps to combat genuine hate speech. Now that the judgment has set out in some detail the extremely dehumanizing and hateful violations that flow from the gratuitous display, even in the current society, one expects AfriForum to live up to its own words and thus help build an inclusive South Africanness of all citizens united in their diversity, based on mutual respect and genuine acknowledgement of equal dignity, despite the superficial differences in the skin color. Even FAK did acknowledge that, quote, the display of the old flag is frowned upon, close quotes. What was missing from its response and submissions was an attempt to view gratuitous, i.e. almost purposeless, close bracket, display of from the perspective of victims of the apartheid oppression, whose hurt is sought to be protected. What FAK too may appreciate is that the order sought and granted is not a quote-unquote total ban, if one sees it as a ban, which it is not. It is rather a prohibition which is carefully guided, falling within the ambit of the proviso in Section 12 of the Equality Act. FAK itself made an uninvitement commitment in paragraph 26 of its affidavit that, quote, whatever the outcome, the FAK is willing and able to work together with any organization or individual genuinely seeking to foster a social relationship of mutual respect for the cultural, historic identity of all cultural groups in South Africa, close quotes. That seems to be the statement of an organization that is prepared to turn a new leaf and to engage about other cultures as well in the spirit of inclusivity, of diversity. This then is its time. South Africa will move faster towards its vision of one nation united in its diversity. The parties in this case were agreed in their submissions that whatever the outcome of this case, none of them seeks cost against the other. In the result, I make the following order. 1. In terms of Section 21(1) of the Promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000, the Equality Act, it is determined that the display of the old national flag of South Africa, introduced from 31 May 1928 and used throughout apartheid until it was abolished on 27 April 1994, that is the old flag, at the Black Monday demonstration on 30 October 2017 constituted A. Hate speech in terms of Section 10(1) of the Equality Act. B. Unfair discrimination on the basis of race in terms of Section 7 of the Equality Act. C. Harassment in terms of Section 11 of the Equality Act. 2. In terms of Section 21(2) of the Equality Act, it is declared that, subject to the proviso in Section 12 of the Equality Act, any display of the old flag constitutes A. Hate speech in terms of Section 10(1) of the Equality Act. B. Unfair discrimination on the basis of race in terms of Section 7 of the Equality Act. C. Harassment in terms of Section 11 of the Equality Act. There is no order as to costs. I hand down the judgment. Court adjourns.
All rise.